My name is Jamie Dreher. I'm a partner with Downey Brand in our financial restructuring and commercial law group. I've been moderating these panel discussions that we've been having for the past few weeks and going to move forward again today. And we actually have the next 2 Fridays planned on ongoing topics of interest. We're trying to mix in a few different practice areas and issues of expertise. Today, the 4 of us are going to be giving a presentation. We're going to hear about some ongoing and immediate employment and workplace issues from our employment law partner, Cass Farinini. After Cass, Danielle Stevens, who's a partner in our real estate group, is going to talk about some current real estate issues, including commercial tenant issues and eviction moratoriums and the like. Sean Filippini, who's a partner in our construction and litigation group, is going to talk about some issues of immediate concern to folks in the construction industry and who are also undergoing construction projects. I'm going to talk at the end on a topic that it might be on a lot of folks' minds, and that is the Paycheck Protection Program, which I'll talk a little bit more about later, but the guidelines came out in applications last night, and we're going to run through some issues there. First of all, just a little housekeeping here. We think we have everybody's microphones muted, but please, just to be sure, please mute your own microphone on your end so the sound comes through clearly for everybody. At the bottom of your screen, you should see a chat bubble. Feel free to go ahead and post questions. We solicited and received quite a few questions in advance that we hope to touch on today. But as we're speaking, please feel free to text questions. We're going to reserve a few minutes at the end of the hour to try to address some of those questions. And I think it's a blue chat bubble, if I've got it right. I think it looks different on your end than ours. Without further ado, then, we're going to go ahead and get started, and I'm going to turn things over to Cass.
Hi, this is Cass. I'm a partner in the employment group at Downey Brand. I'm an employment attorney. And so what I'm going to talk about today are some the new Department of Labor regulations that are effective April 1st, that came out on April 1st, that explain a lot about the emergency FMLA and the emergency paid sick leave laws. And these regulations are significant and large and all-encompassing. They're very detailed. So what I try to do today is I'm going to hit some of the questions that I've been getting from employers, the main questions that people seem to be asking, but know that there's a lot in these regs. So here we go. The first question is this issue of, here in California, does Governor Newsom's order equate to a quarantine or isolation order under the FMLA? And the regulations do clarify that. And the reason it's important to know that is obviously to know whether you're subject to the act, but also to know whether you're going to be able to get the tax benefits that are promised from paying out this leave. So nice to know. Basically, the answer is that quarantine or isolation orders include those that advise citizens to shelter in place, stay at home, or otherwise restrict their mobility. So now it is very clear that the statewide order from Governor Newsom is an order that qualifies under the act, which is nice. Keep in mind, though, that if you are an essential business, you're still exempted from the act. So that's nice that it clarified that for us. The other thing that it clarified in this area is that an employee who is subject to one of these statewide orders still cannot take paid sick leave where the employer doesn't have work for that employee. So for example, if I'm the coffee shop worker and the coffee shop closes down because there's no business, the employee has no work. And so regardless of the stay-at-home order, there's no work or telework, and so that employee would not be entitled to the paid leave under the Act. The second thing I'm going to talk about is something that is of concern to those small employers with less than 50 employees. As you may recall, when the laws first came out, there was a cryptic, unspecified action that was going to be taken by the Secretary of Labor to provide an exemption, small employer exemption for those folks. And that information has now come out. So the question is, when may a small business, i.e. one with fewer than 50 employees, deny paid sick leave or expanded FMLA if the son and daughter's school or place of child care is closed? Those small businesses are exempt where allowing the leave would cause the small employer's expenses and financial obligations to exceed available business revenue and cause the small employer to cease operating at minimal capacity. There's another aspect of this, and that is that if the absence of the employee or employees requesting the leave would pose a substantial risk to the financial health or operational capacity of the small employer because of their specialized skills, knowledge, etc., and the small owner can't find enough qualified people to take their place, and then will be unable to operate at that minimal capacity, those are the circumstances under which the leave may be denied. So that's nice that there's finally some light shed on that. There's also a second bit of interesting help for small employers with less than 50 employees. And that is that in the enforcement realm, if you deny your employees the right to take the leave, etc., there's some penalties that apply. The new regulations say that an employee, if you're a small business that would not otherwise be subject to the FMLA, so less than 50 employees, your employees can't bring a private right of action against you for violations. This means that your employees cannot sue you directly themselves for violations. So that's nice to know. Keep in mind, however, that the Department of Labor can enforce these laws. So while it's nice that employees cannot file suits and get their attorney's fees and all of that, do bear in mind that there still is an enforcement mechanism for this, and that is the employee could always go to the U.S. Department of Labor, and the Department of Labor could initiate some kind of administrative action. Finally, the last question I've been getting a lot is, well, what are the documentation requirements? What information can we get from our employees that allows us to document this leave? Because, as you may recall, you have an obligation to document these things if you want that tax break. So there has to be something that you can get from somewhere to confirm that, yes, the employee is qualifying for the emergency FMLA and paid sick leave. So basically, on a very basic level, the regulations provide that the employee must provide the employer with a signed statement that includes their name, the date for which the leave is requested, the COVID-19 qualifying reason for the leave, and a statement representing that the employee is unable to work or telework because of the qualifying reason. So those 4 things, those go on every bit of documentation. The signed statement from the employee has to have those 4 things. Plus, there's additional information that you can get depending upon the qualifying reason for the leave. So if it's a qualifying reason is that the employee cannot work or telework because of a quarantine or isolation order, the employee must provide with the name of the entity issuing the order, which here in California obviously would be, Governor Newsom's statewide order, or the healthcare provider, if a healthcare provider has told them that they need to self-quarantine. If the leave is to care for a child, then the additional information that the employer can receive is the name of the child, the name of the school or the child care provider that is unavailable, and a statement from the employee representing that there is no other suitable person available to care for the child. Finally, if the qualifying reason for the leave is either the employee's own serious health condition or the need for the employee to care for someone else with a serious health condition, the regulations clarify that the normal FMLA certification requirements apply. And so those are the three issues that I'm touching on today. I'm sure that as time unfolds, we will get even greater detail and further clarification about this. And, keep in mind too, that if you have particular questions regarding how those regulations work, they're available on the DOL's website. And of course, we're going to be sending out alerts on that as well. So for now, I'm going to turn it over to Danielle.
Thank you, Cass. This is Danielle Stevens. I'm a real estate partner at Downey Brand. And today I'm going to be talking about commercial eviction moratoriums. So in mid-March, California's governor issued an executive order which invited cities and counties to implement rules barring commercial evictions when the grounds for evictions was failure to pay rent, so long as that failure of rent was tied to COVID-19. Many local jurisdictions actively implemented such eviction bans, including the city of Sacramento, city of Elk Grove, city of Davis, city of Los Angeles, county of Los Angeles, and city of San Francisco. Other jurisdictions, like the county of Sacramento, have implemented eviction bans for residential properties, but not commercial properties. So if you're a tenant and you want to know what protections you have to go to your local city website. If you don't live within a city boundary, then go to your county website. If you're a landlord, before responding to any requests for a tenant for rent forgiveness or rent forbearance, you'll also want to check your city and county website, as you don't want to say no to a proposed plan that's already permitted by law by the city or the county. So let's talk about eviction moratorium orders as it relates to tenants. So forgiveness versus forbearance. In the local orders that I've reviewed, none of them relieve the tenant of the obligation to pay rent. Rent is still owed, it's just not owed right now. So there's no rent forgiveness. We're talking about rent forbearance. So the rent obligation is being pushed off to another day. For the city of Sacramento and the city of Davis, the county of Los Angeles and the city of San Francisco, that payday is six months after the emergency order is lifted. So 6 months after the shelter-in-place order is lifted, all rent that the tenant has delayed in paying is now due and owing. For the city of Elk Grove, the forbearance period is 4 months, not 6. And for the city of Los Angeles, it's 3 months, not 6. So how will a tenant ever be able to make such a large payment? The answer is by applying for the SBA loans, any available city loans, and now the state loan, whose program I think was made available to applicants today. A smaller tenant who does not at least apply for one of these programs or loans is unlikely to have the rent money required after the 3 or 6 month forbearance period to pay landlord. So let's talk about notice requirements. Some of the eviction moratorium orders require a tenant to notify a landlord before the rent is due that they have a covered reasons for a delay in payment. Other ordinances allow for a tenant to notify a landlord after the date rent is due. Obviously very important for each tenant to know when their notice is due. The city of Sacramento and the city of Elk Grove require tenants to give notice before rent is due. The city of Sacramento even created a form that you can find online that tenants can fill out and send to their landlords. But other cities, like the city of Davis, allow tenants to notify landlord after they have failed to pay rent that they have a covered reason for a delay in payment. So Again, it's important to know exactly what city or county you as a tenant are in and what rules apply to you. Qualification requirements. Similar to what Cass was explaining earlier, you have to look at the qualification requirements as it relates to commercial eviction moratoriums. So who can actually qualify for protections under these moratoriums? Some qualification requirements are broad and are meant to allow as many tenants as possible to qualify. And the grounds for non-payment include loss of income due to the workplace closure or reduced hours, or loss of income due to school closures. Others are much more narrow. I'm going to give you an example. The city of Elk Grove. A tenant in the city of Elk Grove has to show that there's not less than a 20% reduction in the average gross monthly business income in order to qualify. The city of Elk Grove and the city of San Francisco also provide that their protections do not apply to commercial tenants with a gross receipt of $25 million or less in 2019. So a tenant should not just fire off a notice to the landlord to provide that they can't pay rent, because you need to understand if they qualify for the protection of the specific order that applies to them or not. Now let's talk about partial payments. Most of the orders I've reviewed require tenants to pay what they can towards rent. So if the tenant elects to pay nothing, then a tenant could should anticipate that the protections they're seeking could be challenged by the landlord. Using again the city of Elk Grove as an example, the order was crafted to encourage tenants to at least pay something. The order provides that if a tenant pays not less than 50% of their rent, they are deemed to have paid the portion of rent that they could pay. So for example, if a tenant pays 60% of their rent because their income has dropped by 40%, they are deemed to have paid the portion that's reasonable for them to pay. On the flip side, if you have a tenant that pays less than 50% of the rent, the protection the tenant is electing can potentially be challenged by the landlord. So if you're a tenant, you need to evaluate, you can't just say, I'm not going to pay nothing. You really need to evaluate what it is that you can pay and pay what you can to the extent that your order that applies to you tells you to do so. There's also a supporting documentation component to these ordinances, similar to what Cass was mentioning. Most of the orders require tenants to submit documentation evidencing the loss of income. So again, if you haven't experienced loss of income, you aren't paying rent, and it isn't a good idea to claim this protection. Make sure you document your loss and that you provide this documentation to the landlord. A final comment I wanted to make on the tenant side of things. If you are not in a county or a city that has a commercial eviction moratorium, such as, again, the County of Sacramento, and you are a larger tenant and you use a tenant favorable form lease, as you can imagine, this is a small group of people, it may be worth looking at your force majeure provisions in your lease to see if it allows you to potentially abate rent. For a majority of tenants, this will not be a worthwhile venture, as the force majeure provision will say that you're excused from performing under the lease except for the payment of rent. So for a very lucky few, the force majeure provision may be a winning ticket for rent abatement, but for a majority of people, not so much. So Mary, I think we're on to the next slide now. So next, I'm going to talk about landlords. The evictions moratoriums affect more landlords because they're not able to evict defaulting tenants. It's temporary. Even though the courts are not open now and you can't evict defaulting tenants right now, you can start preparing for when they're going to reopen. When the courts reopen, or if your particular court is accepting online filings or filings by mail, you can still file an unlawful detainer action against a tenant for a default that existed prior to the enactment of the eviction moratorium, or for a non-monetary default occurring at any time. So again, landlords can still evict tenants for a default that existed prior to the enactment of the eviction moratorium, or for a non-monetary default when the courts reopen. Landlords can also challenge a tenant's defense that they have a covered reason for a delay of payment. So we went through kind of all the requirements the tenants have to fulfill in order to claim these protections. If they can't check those boxes, the landlords can challenge that defense. So was the tenant's notice given in the manner required by the order? Was it given before the default or after the default? What did the order require? Did the tenant meet the qualification requirements? Did the tenant make partial payments when they could have? Did the tenant fail to provide supporting documentation for their loss? These all might be appropriate grounds for challenging a tenant's defense to your unlawful detainer action. I also want to note that I think my recommendation would be for all landlords to stay in touch with your tenants. I think that landlords should be informed about what loans tenants are applying for. Being aware of what your tenants are doing or not doing are really going to give you a lot of insight as to who's going to come out of this with a rent check for you at the end of the day, who is not. Also, my recommendation is to start discussions with your lenders. From discussions with many of my borrower clients and my lenders clients, a lot of these conversations have just started. There's not really a path forward that has been chosen by lenders for borrowers who can't make payments due to tenants not paying them. I think that those conversations are starting, and they're good conversations to continue to have. So that is my presentation on the commercial eviction moratoriums. And now I'm going to send it off here to Sean to talk with you about the construction industry.
Hello, everybody. I'm Sean Filippini. I'm a partner here at the Downey Brand firm, and my practice focuses on construction and litigation. First thing I want to touch upon today is the industry generally. What's going on with the construction industry amidst the various shelter-in-place orders, and how has the construction industry been impacted by those orders? Question, is construction continuing? And the answer to that is, well, it depends. So as you probably all recall, the governor on March 19th issued an executive order, which was effectively the shelter-in-place order for all of us. And that order identified industries that were deemed essential and industries that were deemed not essential for purposes of continuing work. In the governor's order on March 19th, construction projects generally were deemed essential critical infrastructure projects under the governor's order, and therefore, under the governor's order, essentially all construction projects that were ongoing as of March 19th could continue. That said, local jurisdictions have since proceeded to enact more restrictive requirements than the governor's March 19th order. The more restrictive and the most restrictive order by local jurisdictions was implemented earlier this week. And it was essentially a Bay Area order that was much more restrictive than the governor's order. There was an order issued on March 31st by the 7 different Bay Area counties: San Francisco, Alameda, Contra Costa, Marin, Santa Clara, San Mateo, and Sonoma, that essentially stated that as far as construction went, the realm of construction projects that were going to be permitted to continue were going to be limited to essential infrastructure projects such as airports, utilities, oil refining, roads, public transportation, and telecommunications construction projects. Affordable housing projects, that constitutes housing projects where at least 10% of the units are low-income units. And then public works projects, but only public works projects that are deemed essential by the local governing body who is responsible for the construction project. So effectively, with the Bay Area order on March 31st, essentially any commercial or residential project, let's put it this way, most residential and most commercial projects throughout the Bay Area counties have been shuttered and shut down completely since March 31st. Here in Sacramento and throughout the Central Valley, we are still governed by the governor's orders. So construction projects throughout Sacramento and the Central Valley, by and large, right now as we speak, are continuing to progress and are continuing currently. Now, of course, that's always subject to modification, and in light of the past weeks that we've all lived through, we all know that things tend to change hour by hour amidst this pandemic, so that could change. But currently at the moment, as we speak, construction projects are continuing in Sacramento as well as throughout the Central Valley. Now, for construction projects that are continuing, of course, social distancing protocols are implemented and have to be implemented, and we're all very well aware of those now, which is signs must be posted at the construction site identifying the dangers from the COVID-19 virus, 6 feet social distancing whenever and wherever possible on construction sites, regular disinfectant areas, hand sanitizers, etc. So now switching to contractors that are on projects and working on projects, how to deal with potential time impacts that the COVID-19 virus could cause contractors for ongoing projects. For example, project in the Central Valley or Sacramento that's currently ongoing, somebody in a crew comes down with a fever and doesn't feel well. The rest of the crew decides they don't want to take a risk, and so an entire crew of a contractor just stays home and stops working and stops making progress. Or the crew dwindles because some members are not comfortable working under the current circumstances. Or, for instance, material suppliers slow down and material supplies to the construction site slow, thus impacting the contractor's work. So how should contractors deal with that? What are best practices for contractors to deal with those scenarios in situations where construction is ongoing and there is no order shuttering a project? So the answer to that is, first and foremost, look at your construction contract. Construction contracts typically do not have force majeure provisions like leases and other types of contracts. But what construction contracts typically always have is detailed provisions that contemplate things that deal with time extensions and increases in compensation in the case of changed conditions. Almost always, construction contracts have strict provisions requiring written notice of potential delays as soon as a contractor becomes aware of those potential delays. So what we have been advising our contractor clients is, to the extent that they are actively involved in ongoing construction projects right now, that they immediately send a notice letter to the owner, and in the case of subcontractors, to the general contractor, notifying the owner or general contractor of the current state of the pandemic, that it's an ever-changing and evolving solution, that it has the potential for significant time and cost impacts for the contractor's performance on the project, and essentially functioning as a preemptive notice of changed conditions that sits as a placeholder for that contractor. To be able to be in a situation where it's satisfying contractual notice requirements for changed conditions. Now, of course, from there, if the preemptive letter is sent and something later occurs, such as somebody in the crew gets sick, or the crew gets spooked, or a material supplier is delayed and progress is delayed on the project, then we're advising contractors then at that point immediately send a follow-up letter to the owner or the general contractor, notifying them of the further circumstance and the further delay on the project, and following the written notice provisions from there. Now, of course, if contractors experience time impacts, delays, cost impacts related to COVID-19, of course, like any other claim, our advice is extensively document those issues. Document those time impacts, document those cost increases, and document those things in real time, as you would with any other claim. And the purpose of doing that, of course, is later on, hopefully sooner rather than later, when we are through this current crisis, and there is a dispute about whether there's a justified entitlement to a time extension or cost increases to the contractor, then the contractor at that point is in a strong position to be able to back up and justify those claims for extra time and extra work. So with that said, I will pass it over to Jamie to take us home.
Thanks, Sean. Hello, everybody. Jamie Dreyer again here. I think the order of the day and the thing that we are hearing the most about and receiving the most questions about is the Paycheck Protection Program, which is a loan program, which is part of the recently passed CARES Act, which I will get into, talk about some of the contours of which, and give you the latest information that we and our clients and our banking contacts have. So first of all, you all know about what's called the CARES Act, which was passed and signed into law last week, which is CARES stands for Coronavirus Aid, Relief, and Economic Security Act. So we'll call that the CARES Act. And that's the most recent and largest economic stimulus package. As part of the CARES Act, $350 billion of the amount is earmarked for what is now known as the Paycheck Protection Program, which is an initiative to provide 100% federally guaranteed loans to small businesses. Just kind of an interesting note, the current circumstances and this current massive economic stimulus package brings back memories of 2008 and 2009 and the economic challenges our country was going through then. At that time, the circumstances were different. The economic strain was caused by banking, financing, interest rates, treatment of mortgage loans and subprime mortgages, and things like that. So if you recall, that TARP program back then, most of the money went into banks and financial institutions. This is different. The CARES Act and the Paycheck Protection Program, I'll either say Paycheck Protection Program or PPP is what people are referring to the program as, is a little bit different. It goes directly to small businesses, which, by the way, is a defined term and a term of art, which we'll talk about a little bit. So a few resources for you all. There's a lot of information out there. I'm going to try to summarize what I know and provide access to documents that we have. So we received some questions in advance, well, a lot about the program, and then also about access to documents. The PPP application form came out last night. Do we have a link to it on our website yet? We do. Okay, so there's a link to the application form on our website, which you can take a look at. It is very basic and very simple. And other than the documentation required regarding your payroll, which we'll get into, it's 2 pages with another 2 pages of warnings and restrictions and requirements. So applications are going to be accepted starting today. The SBA is anticipating that these applications need to be submitted as soon as possible. In fact, the SBA's own guidance says, quote, there is a funding cap and lenders need time to process your loan. So speed is of the essence. The application is not too onerous, and the guidelines appear fairly simple to comply with. I would also note that there was an article in the Wall Street Journal, was it this morning or yesterday, Mary? There was supposed to be a conference call last night with the National Association of Government Guaranteed Lenders, which is an SBA lender. This is this morning, trade group, and they had a conference call set for last night when the regulations and guidelines and application form from the Department of Treasury were supposed to issue, and they had to cancel it because by the time of the call yesterday evening, the regulations and guidance had not come out. It's come out now, and so we're kind of working in real time on this. A couple of very specific questions before I get into the program parameters. Some folks have asked what the contours are and or whether nonprofit corporations are eligible to participate in this loan program. We have lots of nonprofit clients. The answer is they are in the same fashion that other eligible small businesses are. Small charitable organizations also might be eligible to receive funds pursuant to a loan program that was passed with one of the earlier iterations of the economic stimulus packages. which is called an economic injury disaster loan. And there's some immediate funds available under that formulation. However, if your organization is participating in the EIDL loan process, you may not be eligible to participate in the current PPP process. So 501c3s are eligible. We also have several 501c6 and other not-for-profit entity clients like trade associations. Trade associations typically do not qualify for small business administration loans, and we're not seeing anything in the current legislation, unfortunately, that changes that for our association clients. Another question we got in advance of today is, can somebody provide a list of participating institutions? So we have some of that. So we put up on our website, there should be a link to active lenders in the Sacramento district of the SBA, broken down by all the contact information for the respective lenders, the type of loans they qualify to approve, and contact information, at least for this area, then will be up on our website. Separately, if you go to sba.gov, you can find a list of participating lenders. I've heard kind of anecdotally, and I don't know this for an exact fact, but some of the larger institutions that are already qualified as SBA lenders, and so for which no further qualification is necessary to process these loans, like Bank of the West and I believe Wells Fargo, are only currently taking applications from current clients, and that obviously will change in the future. But one of the reasons for that, obviously, is they're so large and all these institutions are expecting a crush of these loan applications. Turning to the contours of the program. So first of all, no matter what type of borrower you are, all the loan terms are going to be the same for every borrower client. Proceeds of the loan that are processed and used will ultimately be forgiven so long as the loan proceeds are used for payroll and some component of mortgage interest, rent, and utility costs for the next 8 weeks after the loan is made. And another requirement is that employee and compensation levels are maintained. With respect to the loan amount, there's a cap, and I'll get into the calculations. It's roughly equal to a couple of times your average monthly payroll for the last 12 months, depending on what type of organization you are and whether you have employees or independent contractors. Although the payroll cap per employee is capped at $100,000. The Department of Treasury advises that due to what is anticipated to be a high subscription to this loan program, that not more than 25% of the forgiven amount of the loan can be used for non-payroll costs. And we saw that guidance this morning as the first thing. So whatever loan amount you end up borrowing or using, it's mostly forgivable, but only up to an amount where 25% of the loan amount is used for things other than payroll. So it can be used for things other than payroll, but only 25% of it's capped at 25% of the forgiven amount. The loan payments are deferred for 6 months. There's no payments. Starting today, small businesses and sole proprietorships can apply. Starting April 10th, independent contractors and self-employed individuals can apply. Other regulated lenders are coming on board. The Department of Treasury is trying to qualify them, and that's happening. And I'm sure the authorities are kind of overwhelmed with processing that. You can apply through any existing SBA lender or federally insured depository institution. So all businesses, nonprofits, veterans organizations, tribal business concerns, sole proprietorships, self-employed individuals, and independent contractors, I'm going to loop back to that in a minute, with 500 or fewer employees can apply. So 500, if you have more than 500 employees, that cap is actually lifted only for certain industries like the leisure and hospitality industry. If you have more than 500 employees, but less than 500 employees per location, you may still qualify. Alternatively, the NICS code qualifications for your type of industry and business sets forth small business administration size guidelines. And so you will need to look to see where your business is, and it's a tax return. Your CPA will know the answer to that question, but you'll look up the publication and it's a tax return qualification and categorization number. What's required for the application is the application itself, which, like I said, if it's not up there now, it'll be on our website. The application and required documentation, which is mainly made up of payroll information, is required to be submitted by June 30th. One of the prior or existing requirements of SBA loans is that you're required to demonstrate that you weren't able to obtain these requested or loan funds from other sources, has been waived in connection with the PPP program. Under current guidelines, the program is open until June 30th, but again, Department of Treasury says you're encouraged to apply as quickly as possible because there's a funding cap and lenders need time to process the loan. With respect to what will happen in the future if the funding cap is met or blown over, it's a complete unknown. Further legislation would be required to make additional funds available if that $350 billion is called for, which I don't really have any insight into when or how that might happen. You're allowed to take out one loan and one loan only under this program. Loan proceeds can be used for payroll costs, including benefits, interest on mortgage obligations, rent under lease agreements, and utilities. There's payroll cost is really a defined term. Payroll cost includes salary, wages, commissions, or tips, and like I said earlier, capped at $100,000 on an annualized basis for each employee. Employee benefits also includes typical vacation, parental, family, medical, or sick leave calculations, payments required for the provision of group health care benefits, including insurance premiums, and payment of retirement benefits, which is important. It also includes state and local taxes assessed on that compensation. For a sole proprietor or independent contractor, the wages, commissions, income, or net earnings from self-employment are capped at $100,000 and then on an annual basis for each employee. The PPP covers sick leave, although the CARES Act expressly excludes qualified sick and family leave wages for which credits are allowable under other provisions of the law. So general guidance is PPP does cover sick leave. As far as the loan amount, loans can be up for up to 2 months of your average monthly payroll cost from the last year, plus an additional 25% up to a $10 million cap. If you are a seasonal or new business, there's a different applicable time period. Again, payroll costs capped at $100,000 annually for each employee. As far as the forgiveness, if you use the money for anything other than payroll costs, mortgage interest, rent, and utilities over the 8 weeks following funding of the loan, you will have some repayment obligation. But if you don't, and like I said, subject to the yet to be determined forgiveness regulations, Treasury is anticipating a 25% cap on the forgiven amount for things other than payroll. Also, you will have repayment obligations if you do not maintain your staff and payroll. For example, if you decrease your full-time employee headcount during the relevant time period, you will have a repayment obligation. If you decrease salaries and wages by more than 25% for any employee that made less than $100,000 annualized in 2019, you will have a correlative and calculated repayment obligation. You will have until June 30th, 2020 to restore your full-time employment and salary levels for any changes made between February 15th and April 26th of this year. So obviously, the forgiveness calculation and the point of all this is to keep people employed and to bring people back to employment using the PPP funding and loan proceeds to get them there. I don't have many details on exactly how the loan forgiveness component is going to work. Documents will need to be submitted. There's going to be some kind of documentation requirement. And at the end of the relevant time period, borrowers are going to need to make a forgiveness application demonstrating that they've met some of these requirements. The interest rate as of today, the interest rate is 1%. As of last night, it was maybe half that or inching up towards 0.75%. And as I understand it, generally some of the large financial institutions and their associated trade groups made the point to the government that at a 1% or less than a 1% interest rate, they can't afford to cover the administrative costs of the crush of work expected in administering and making these loans. So in response, Treasury did set the interest rate at 1%. Payments are deferred, like I said, for 6 months. If you do end up having a repayment obligation, however, interest will continue to accrue over that time period. The loan matures in 2 years. There's no prepayment penalties, and a big change to prior SBA loan requirements and guidelines include: 1, no collateral is required. It's an unsecured loan. Nothing is required to be pledged, and no personal guarantee is required. As part of the application process, you're simply required to certify for SBA loan processing and application requirements. I'm just noting that a submission of false information on an SBA loan application is a federal crime. So in the government's mind, the self-certification program, as backed by criminal law enforcement, is it's sufficiently comprehensive. But you are required to make a certification that the loan is necessary due to current economic uncertainty, that you will use the funds to retain workers and maintain payroll or to make mortgage, lease, and utility payments, that you have not and will not receive another loan under this program, and that you will eventually provide the lender sufficient documentation to verify the number of full-time equivalent employees on payroll and payroll costs, and then also certifications about truth and accuracy of the statements made in the application. Ultimately, you also, with respect to some of these calculations and the actual loan amounts, the lender is actually going to be making that final calculation. So that's PPP in a glance. We'll put up on our website as many materials as possible. I'm kind of gathering them now. They're coming through to us. I mentioned 501c. Somebody posted a question that I'll just jump to now that they wanted restated. Whether a borrower can receive both a PPP loan and an EIDL. The answer, as we understand it, is no. We also understand, however, that some businesses have already begun the application process for both loans while they determine whether they qualify for either. A borrower, however, that does have an existing EIDL unrelated to COVID-19 may apply for a PPP loan with the ability and option to refinance that current EIDL loan balance into the PPP loan. Finally, if a borrower receives that $10,000 EIDL grant, the amount would be subtracted from the amount forgiven under the PPP loan. That's all I have on the PPP loan program right now. I wanted to mention a couple of other issues that have come up in other legislation and things that I'm seeing in my practice. I'm a bankruptcy and restructuring lawyer. I'm getting a lot of questions and issues right now. Obviously, businesses of all sizes and individuals are having difficulty making payments on debt and paying bills right now. Oil and gas companies, for example, you may have seen in the news that I don't know what oil is at right now, but it's as the result of a confluence of circumstances. I think it reached below $20 a barrel. Oil and gas companies are in bankruptcy cases nationally now, constantly. Retail's been hit really hard. You know, honestly, retail's been hit really hard for the last 5 years, and that has been one of the most active spaces in the business bankruptcy world, and it's only accelerating. Obviously, restaurants and hospitality are the hardest hit right now. Some fairly large leisure and hospitality businesses are ending up in bankruptcy cases. Small local restaurants really are not, because margins are so thin. At least what I'm seeing is if you're a restaurant, you're closed, and you get to a point where you can't make payroll, at that point, there's really not much you can do about it. And closure is on the line. I would note, as part of the recent legislation and from a Chapter 11 bankruptcy perspective, just last year, unrelated to current circumstances, Congress passed a new provision called Subchapter 5 of Chapter 11. Chapter 11 of the Bankruptcy Code is the provision a lot of you all have heard about, which provides businesses the ability to reorganize their balance sheet and restructure their obligations with all of their creditors, all of their partners, and the like. Chapter 11 is a very expensive, difficult, time-consuming process, and because of that, it kind of winnows the field and restricts the ability of a lot of companies to take advantage. So in response, like I said, Congress last year passed a new provision of Chapter 5, which really streamlined the ability of smaller businesses to get into and navigate a Chapter 11 case by removing many administrative and reporting requirements and lots of other things like that. And it just went into effect, I think, at the end of February this year. The debt limitation for those small businesses is $2.7 million. That's not a lot. For a lot of smaller businesses, the debt load is higher than that, and it's about to get higher for a lot more businesses. So as part of the CARES Act recently passed, a change to the bankruptcy law was included, which lifted the debt limitation for 1 year for these new Subchapter 5 of Chapter 11 small business debtor cases from about $2.7 million to $7.5 million. So a small business with up to $7.5 million in debt should be able to get into and navigate a Chapter 11 reorganization process for a fraction of what it might cause larger businesses. That's all I have on my agenda that I'm prepared to talk about. We might have some questions we're able to get into. A lot of us are appearing remotely, so we're trying to share some of the questions. One of the questions I'm going to pass to Mary Isley internally at our firm here was, can you scroll back up to the first question? Oh, just talk about where we're posting information, how we're publicizing, what content we're providing, and things like that.
Hi, yes, this is Mary Isley. I'm the marketing manager over at Downey Brand, and we would love for you to share our information. We post all of this on our website. We have a COVID resource page on our website where you can find all this information. So yes, please share that information with your colleagues. If you sign up through Constant Contact, you can always forward those messages from Constant Contact to any of your colleagues as well. So thank you very much. We did have a couple of other questions that I think Cass Farinini was going to address, so I'm going to turn it over to her right now.
Thanks, Mary. There were two questions. The first question was from Jana, and the question was whether or not Governor Newsom's order is considered to be a quarantine or isolation order. And the answer is yes. The new regulations clarify that a order that says shelter in place is a quarantine or isolation order under the emergency FMLA. And then there was another question, and that related to Sean's mention of a crew where the entire crew refuses to work because one individual has been deemed at risk or is actually medically quarantined, and would the rest of the crew qualify for paid sick leave under the new federal law? So my response to that question is, first of all, that if you have construction, you are likely within the class of employers that fit into the essential critical business infrastructure exception that takes you out from under these laws. So you would have to analyze that part of it as well. But more fundamentally, because this could happen in any work environment where one person is medically at risk and has to be off, so then the rest of the people say that they don't want to come to work. It's determined on a case-by-case basis as to whether somebody qualifies under the act. You look at the particular employee and what that particular employee's circumstances are. So somebody might be age 65 and their doctor says you need to stay away from other people because you've got all kinds of underlying pre-existing conditions and it's too risky for you to be out there. That's that guy. That isn't the entire crew. And so you should be qualifying the rest of those people on that crew to see what their particular circumstances are as to whether that act applies to them or not. So the short answer to that question is no. Just because one person on a crew can't work doesn't mean that the whole crew can't work. And so those are the questions that I can answer.
There's a question regarding eligibility for the PPP for a for-profit subsidiary of a 501c6. I don't know the answer to that question, but I do know that under the current act that there are several changes to the definitions of affiliated companies. And I think most of those definitions have to do with qualifying for the size limitation of the SBA. But wherever that question came from, you've got my contact information in the slides. Feel free to shoot me that question directly. I'd have to look into it and pull in our partner, Dale Stern, who is our in-house resident expert on nonprofit and association law. So we are going to end there. We are going to have another webinar next week. We're currently slated to have a further update on employment issues. One of our litigators is going to come in and talk about and offer information and guidance to people who have ongoing court cases, what that is looking like, and what's happening in that arena. One of our public agency lawyers is also going to come in and talk about issues facing public agencies for our public agency clients. And our insurance coverage lawyer may or may not be available due to a personal medical issue unrelated to COVID. So look for further information and emails or go to our website from us. And thank you everybody very much for your interest in participating. And we're happy to be here with you and look forward to serving you all. Thank you.
Thank you, everyone.